Hello, in this video, we will revise IPR, plagiarism and digital property rights. What we are going to do is to solve a case study around it, to revise it and simultaneously see some short questions on it to cover the topic. Before we start questions, here is a quick summary of IPR, plagiarism and digital property rights. IPR stands for Intellectual Property Rights, which are right over property that includes intangible creations of the human intellect. It includes inventions, literary and artistic works, designs and symbols, names and images used in commerce. The most well-known types are copyright, patent, trademark, and trade secrets. Patent generally apply to product and processes. You need to register it in each country where you require protection, and it is valid for 20 years. A trademark is distinctive sign, label, logo name or slogan which identifies a product or service. It needs to be registered. The initial term is for 10 years, but it can be renewed post that. Copyright typically applies to a wide range of creative, artistic or intellectual work like books, music, movies, etc. It automatically comes into force when it is created and lasts for 60 years after the death of the author. With content moving online, nowadays DPR or digital property rights has become common. It refers to individual rights on digital assets or information available online. For example, online accounts, email accounts, photos, videos, blogs, or websites which you own. There are various threats that we see on digital properties online. First of them is plagiarism, which effectively means stealing someone else's intellectual work and presenting it as your own. Then there is infringement, which could be copyright, patent, or trademark infringement as well. It is basically unauthorized use of someone's IP. For example, hackers using cracks and keygens to penetrate license system. There are various steps you can take to protect your digital properties. First is to deploy anti-tamper software or solutions. It prevents hackers from manipulating or reverse engineering your digital properties. Other option is to have a tight terms of service to be included while sharing your software so that you have a good legal backup. The third option is to limit sharing by deploying a digital right management software. This completes our summary. You should pause and take a screenshot of this for your last day revision. Let's do a case study now with questions. We will read this together first. Cyber ethics is exploring appropriate and ethical behaviors relating to online environments and digital media. It includes plagiarism, bullying, and hacking to name a few. Digital property or digital assets refer to any information about you or created by you that exists in digital form, either online or on an electronic storage device. Digital rights management (DRM) is a systematic approach for copyright protection of digital media. Examples of digital property include any online personal accounts such as email and communications, social media account, photo and video sharing, video gaming, online storage, and websites and blogs that you may manage. There are 4 primary types of intellectual property that can be legally protected: patents, trademarks, copyrights, and trade secrets. Each has their own attribute requirement and cost. So this is the case study. While I am doing the questions, I would recommend that you pause the video on each question while I am reading it and try to attempt to solve each of them before I give the answer. So the first question on this is, what is full form of IPR? The options over here are intellectual property rights, intellectual people rights, intellectual property rate, intellectual property risk. The correct answer over here is A, intellectual property rights. Next question is, how can we protect digital properties? The option for this are make digital property tamper-proof, add legal clause to your software digital properties, limit the sharing of software code, or all of the above. The answer here is D, as we just learnt in the summary that we can use any of these means to protect our digital property. The next question is, Nihir managed to download and watch latest movie from a suspicious site. What right of the owner has he violated? The options over here are IPR or digital property rights, FOSS rights, human right, or public right. Answer over here is A. He has violated the IPR or digital property rights. Let's see the next question now. Ronit loves writing stories. However, one day he sees someone else published his story on the net without his permission or giving him credit. What is this unauthorized use called? The options over here are plagiarism, phishing, hacking, or none of the above. The answer over here is A, which is plagiarism, which means stealing someone else's intellectual work. Let's see the next question. How can you avoid plagiarism? You must give credit whenever you use another person's idea, opinion, or theory. You should use quotations of another person's actual spoken or written words. You should paraphrase other person's spoken or written words, or all of the above. Here the answer is D, all of the above, as you can use any of these methods to attribute to author. Let's see the next question. Which statement is incorrect about copyright? The options over here are: it gives owner exclusive right to make copies. It applies to creative work, maybe in a literary, artistic, educational, or musical form. It can extend beyond the territory of the specified jurisdiction. It is valid till the lifetime of creator. Here the answer is D, as it is valid for at least 60 years after the death of the inventor. Let's see the next question. What is the difference between trademark and patent? Trademark is protection of unique name, logos, and symbols, while patent is used to protect inventions or processes. Trademark validity is for 10 years and patent validity is for 20 years. Patent can be renewed, but trademark cannot. And all of the above. Here the correct option is D, which is all of the above. Here the question could also be to write what is trademark or patent, or to give the difference between the two. This completes our case study on IPR, plagiarism, and digital property rights. In our next video, we will cover the next topic of freedom of information and digital divide. You can get the notes and more questions on this topic on our website simplycoding.in too. Thank you and all the best.